बाद में
Assignments list 1, page number 1, serial number 1 to 10, page number 2, serial number 11 to 24, page number 3, 25 to 34, page number 4, 35 to 43, page number 5, 44 to 49.
Formed at request is the matter next week. The matter earlier granted is extended in the next day.
My lord, may I make a mention, my lord?
Yes,
My lord, writ petition number 12064.
what is the submission you are making, counsel? What is the submission? Which serial number? Which serial number?
Mine, my lord.
No, you are making a mention. Which matter? Who's mentioning?
My lord, my lords are granted 2 weeks time, my lord, and it was supposed to be
Which
listed.
matter?
It has not come in the list, my lord. It may
Just wait. Just wait.
grateful.
Page number 6, 50 to 57.
One nimsham. Yes. So inform the other side. The matter is that land acquisition matter. Have you informed the state? You have informed the state, isn't it? List this matter next week.
Page number 6, serial number 50 to 56.
Yes, counsel. Yes. Number good. What is the repetition number?
My lord, yes, so that is me, my lord.
Yes, yes.
My lord, repetition number 12064, my lord, 2023.
Tomorrow. We'll have it tomorrow.
Grateful, man.
50. That request is the matter next week. Only fresh matters. B group, please make a mention. Monday. Monday. 40. Was hearing or only an interim order? Hearing it's not one. Yeah, wait, let us see if today list perhaps.
Lordship, appearing for the petitioner, your lordship. The issue is I'm challenging the orders under 148A, your lordship. Order passed under clause D of section 148A as well as the reassessment order, your lordship.
Yes,
I was not.
Land Council Sri Dilip accepts notice for the respondent. List the matter next week. Consideration of interim prayer is kept open.
Yes. There were some retail activities. This is in my letter in the course of that. Investment order over, travel of the input also may not, I could order also over may not. These today they are not using document. It's not even like a according way was retained and no model has been taken for retaining that season material may not.
The Council Sri Dilip accepts notice for the respondent. List the matter week after next in orders list. Pass the same order. Pass the same order.
Thank you, Lordship. Your Lordship, in regard to GST matter,
Just 1 minute, just 1 minute. Yes, Commissioner of Commercial Taxes. Council Him Kumar, PG accepts notice for respondents 2 to 4. Current Council Sri Madanand Pillai accepts notice for the first respondents. Yes. Yes. Yes.
and your Lordship, that is GST matter, which arises in regard to the integrated goods and service tax law of 2017, which is the companion code of the Central GST Act and the KGST Act. The petitioner for your Lordship is a limited company, it is software and it's been in existence for almost 4 decades, and it has operations across the globe, and it has several subsidiaries across the globe. And in cases where there are no subsidiary companies, is the practice to set up permanent establishments at the site of the customer where software projects are undertaken along with the customer. Now, there are certain circumstances where this petition also has branches across the globe where it does not want permanent establishment. So these permanent establishments are sort of site offices located abroad, where once the work is over in respect of that particular contract, it moves on. So it doesn't have that sort of a presence in certain circumstances. Instead, it has a branch operations abroad. Now, the controversy doesn't arise in regard to issues that crop up in regard to the domestic operations of the petitioner. It's only in regard to the overseas operation that this particular batch of matters come up to your audience. Now, the fact is in very nutshell like this. But when the service tax law was in vogue, that is pre-2017, for a lengthy period of time, there was an investigation conducted in regard to certain import of services at the Department of Foreign Service Tax Department. There was an investigation carried out, which culminated in a series of adjudications and went to tribunal, and the tribunal granted relief to the assessee, which went in appeal to the Supreme Court, and the revenue is currently in appeal there in the Supreme Court. Now that matters to us, when the GST law came, the same issue was again continued in respect of the central team of investigation conducted some inquiries in regard to the same issue in regard to the new GST law, to the effect that these cross-border operations that are carried on by the company in India with its branch offices abroad would fall in the taxment of import of services, and therefore the investigation was conducted and matter pending. As the matter stood, thus, the state GST authority, now here the problem starts. The state GST authority started conducting an audit in regard to this very issue, to which I didn't demur, I didn't obtain. So I subjected myself to the audit, subsequent to which there have been a series of super notices issued to me, demanding integrated goods and service tax under the law of 2017, despite the fact that the state government does not in any manner have any power, authority, competence, or jurisdiction to issue notices or demand or recover any taxes which emerge out of the IGST code, because under the IGST code, it's the central government alone which has the power, authority, and competence to decide cases and demand taxes or conduct audits in regard to IGST, which travels the area of cross-border operations. Now, my objection to this was raised before the authority. I didn't come rushing to your order in the first instance. I went before the authority and specifically told them, look, this particular provisions of IGST Act do not in any manner rest any power for you to do this, conduct this audit, or also to demand taxes of me to the tune of what you have done, and therefore this matter was pending before the central team. Please do not adjudicate this matter. So without bothering about this, they said come for a hearing. I participated in the hearing, and they said, okay, you have jurisdiction. Without any sort of rebuttal to my pleadings, And the just to come on 3rd of August and participate in the hearing and we conduct the hearing accordingly. That's what this endorsement issued to fight to court. And before your lordship, against the action of the authority, which is totally contrary to the mandate of Section 3 of the IGST Act and goes against the grain of Article 246A, 269A, 286, a series of provisions of the Constitution also. Because under the law related to IGST, it's like a customs transaction where a customs levy is imposed in respect of import of goods, it is an import of services. It's only the central government which has the power, authority, and competence to demand, recover, and do anything in respect to the IGST Act. Because the officers are appointed by the board and by the central government, by the Central Board of Indirect Tax Customs and Narcotics, they are the officers empowered to do so. And therefore, this is the first objection that I raised before your Lordship.
What is the endorsement at annexure F?
Endorsement in Annexure F, your Lordship, where very strangely, and this is a very crucial issue, your Lordship, would like to obviously also. When I objected to them, saying that you don't, please don't do anything in this matter, they say that we have the power and quote something which unfortunately is the text of Section 20 of the KGST Act, which doesn't exist in that manner and form. It's a totally and impossible to text. We read that annexure if my lordship would be kindly of the petition be obliged.
Yes.
Page number 219.
Yes.
They seem to purportedly paraphrase the text of this 20 of the KGST. I'll give you also the text of section 19 of the 20 of the KGST Act, which doesn't exist in the form or manner at all. Section 20 of the statute as it stands, KGST, deals with input tax credit and distribution of input tax credit. It doesn't have anything also with what the learned doctor has sought to make out in this particular endorsement. So also section 20 of the IGST Act. So also section 20 of the CGST Act.
Yes, Kumar. Love it next week.
If I may prevail on your lordship, I would very sincerely prevail on your lordship because matters is likely to have a precipitating effect. 3rd of August is the hearing. I would request your lordship to grant us an interim stay.
Now the government advocates states he will instruct the officers not to precipitate it till the next date. I'll keep it open for passing of formal orders on the interim request on the next day. The consideration of interim prayer is kept open. This is the matter in the orders list week after next. Yes. Yeah. Yes.
That proceeding already getting that not take even
Yes, Kumar. and AGA accepts notice for the respondents. Let them get instruction. Live next week. This is the matter week after next. Yes. Yes. Commissioner of Central Tax and Council Amit Anand Deshpande accepts notice for the respondent. It is a similar matter, is it? Seal number? So the same interim order. Interim order at page have you enclosed? No. The interim order passed in the other matters, have you enclosed a copy of them? Attachment. The income tax, service tax. The counsel for the petitioner admits that raised in the present matter been raised in other matters, including in WP 1154/2023. Submitted that the interim order passed in WP 1154/2023 may be passed in the present matter also on the principle of parity. The order granted in the aforesaid writ petition reads as hereunder. Accordingly, there would be an interim order of stay of annexure B and annexure E. It's the matter along with WP 1154 of 22. Yes. Copies to be served on the council for the respondent.
I prefer a different application.
Joint Commissioner of Central Tax. The council chair Amit Anand Deshpande accepts notice for the respondent. Yes.
My different application was, my different was corrected. The authority issued a revision to follow, stating that I being an exporter of software. The revision to follow states that EBRP was not in the name of the unit at Bangalore, pass the order based on the finding in that order.
Take me to that paragraph.
Paragraph 8.
Para?
78, 378, paragraph 40.
Yes.
Want to argue that this will be incongruous, given the fact that EDRPs are issued for specific environment. All submissions of declaration are conducted in the Foreign Exchange Management Act. And given an elaborate and defined feature, EDRPs are specified with certain transactions they cannot be used for multiple people. Also, the next emphasize that the petitioner is engaged in the business of software service and export would therefore not be across other ports of the country as arranged in the code. And these circumstances affect the very jurisdiction issue the impute so-called as regards annexure B, the order rejecting the equal for subsequent period would submit that if on two occasions similar issues are being considered and refund granted, those orders will operate as residual data and third respondent would not have taken a consideration. Those who responding to the first segment of the petition case, submit to the petitioner is agreed by the improved so-called but the ground heard in the petition could also be heard before the second respondent to be considered the same in the backdrop of the circumstances related. We emphasize that the petitioner who has received refund for the earlier period can always avail that petition. In the joiner, submit that the petitioner is constrained to approach in view in the so-called order rejecting.
Go to para 8.
The finding logic is that para 8 and 9 are each one. Para 9 is a lot.
Yes.
The second respondent is peculiarly to the case, and the ground heard must be called upon to decide on the continuation of the case in the light of the petition's specific event, that the assumption that EDR would be used for refund across other courts in the country would be incongruous, and the petitioner export software and EDRs are issued under the appropriate regulations specified to invoices based on declaration and necessary according to the second respondent was accordingly directed to consider continuation of the proceedings in the light of these, but also to decide within a certain time frame just the petitioner is supposed to meet the application. Further, the petitioner must have liberty to file a detailed response with necessary documents with the second respondent to show cause against the application. The light of the aforesaid following.
Now, this Roman 2 has not been followed.
Not being for and the order now you have was on a completely different ground. Which was not taken to show cause at all. It will be to reject my refund claims that these type of orders are being passed again. I have no other option about it. But in all the other ones, the refund is granted based on same document. This one period, I don't know why, for what reason, then my refund application is rejected. The order, the institute will also say that I should clear.
The finding is contrary to the show cause notice issue.
Contrary to the so-called. And it is contrary to law. So I can't claim
that we'll see. Now you just take me to the show cause notice and point out that this finding now recorded is contrary to the show cause notice.
Yes.
Show cause notice at annexure.
Annexure. Yes. It's what.
What is the only ground is there cannot be, there is no nexus between what you are claiming. With
Only ground is so called with the DR report. In fact, my office is I am exported to Bangalore. And once I undertake the export, there is a clear process which is immediately undertake to upload the EDR based on the foreign number. the allegation that in the so-called was that EBRC can be issued at various courts. That was an allegation. But there can never be issued EBRCs at various courts because the export is done through software.
Now go to the finding in the present. Sure, present.
Order.
Yes.
Finding cut to para 98.
Page
98.
annexure K.
Annexure K. It is a complete, I read it complete finding. Very detailed. Annexure F. Page 102 para F.
Now they have not decided anywhere in this order regarding the EBRCs.
Stated that I have made the input tax refund, which input tax was taken credit for a period prior to January 2022.
Let us see. So we'll stay till the next date. The counsel for the petitioner submits that in an earlier round of litigation in WP 4587 of 2023, this court had directed at Roman 2 to record a finding. So it is submitted that subsequent to such order, in the order passed at annexure K, there is no adverting to the issue raised and directed to be decided. Accordingly, there would be interim stay of further proceedings pursuant to annexure K till the next date. The counsel Amit Anand Deshpande accepts notice for the respondent. Liberty is reserved to the respondent to move for modification of the order. Interim order passed upon filing statement of objections. Yes.
Applicant serial number 8, my lords.
Yes.
Lords, this is a petition challenging the assessment order, which is ex parte, and the notice under 148A and order under 148AD, all of which are ex parte, my lords. Without serving even a notice of the assessment order, the assessing officer has determined the total income by taking into credit all the deposits in my bank account and treating the same as the income. So as a result, he has determined a demand of 10.7 crores on my head, whereas the total income according to my computation comes to only 2.67 lakhs. May I take a lordship through the relevant documents, my lords?
Why do you say you are not served?
Lordship may take to, because there is no record of the assessing officer having sent any postal information. And Lordship may take to page 59. I have enclosed the copy of the portal, wherein it is clearly mentioned that there is no email address on the recipient end. Lordship may take to page 59. Page 56, my lords. The portal clearly shows that there is only a from email address. There is no to email address. Page 53, my lords.
Just a minute. Page 60, para 4. No, but the para 4 of the assessment order.
Yes, my lords.
Para 4 of the assessment.
He said that
Now,
there is email address available.
Whether you have registered your email ID.
No, my lords, I'm a small time taxpayer. My email ID was not registered until then, actually, to be honest with this court. All I'm asking before this court is one more opportunity, my lords, so that I can submit all the details and to the satisfaction of the assessing officer. My email address is not registered with the department, my lords. But nevertheless, that does not mean that the assessing officer will determine an income of 10 crores on my head. He could have as well exercised the power under 282 to issue postal notices Because it is not the case of, not the case that the assessing of.
Take precipitative action till the next day. Respondents not to take any precipitative action till the next day. Learned Counsel Sushant Tiwari accepts notice for the respondent. List the matter week after next. Yes.
Obliged, my lords.
Commercial tax. That Council AGA Kumar accepts notice for responding 1 and 2. Council Madanand Pillai is directed to accept notice for the first respondent. Yes. For the third respondent.
Petitioner is a builder. He enters into joint development with the landowner. Landowner get exchange around this 25-75 in this particular KV is 25. Landowner gets 25% of the area. 75% of the area is supposed to be built. Construct and sell it. So the consideration that he takes my lot for 75% which he gets, amenable to tax on his tax. What the respondents want to do is, as a condition to this contract, the developer will have to build for the owners instead of 25%. They want to tax that 25% also. So, no consideration accrues to the builder. Whatever consideration accrues is already taxed. This is the transaction. In this case, my lord, the JDA may not be entered into 2014. Section D. 2014 is entered. I will give the dates. Construction commenced in 2015. What comes to the deed of declaration? Page 1 to 2. The deed of declaration is 1%. That's at 137. 40 the revenue. This is dated by lot 9/8/1970. Kindly note this date. And the purpose. That is 1 month and the week after the GST. The view of the completion of the construction of software technology marketing isn't it? Project was completed prior to the coming into force of the GST. The deed of declaration only was entered into an entity. The statutory provisions that are relevant for this document then of the CGT Act, that it page not 6. Pages.
Section. Yes.
They are otherwise provided in this chapter. Services from both supplied on or after the appointed date. Appointed days was related to persons who contract entered into prior to the appointed date. And the liability tax and the provisions of this act. That portion which falls after 1/7/2017 may not be subjected to GST. What happens to the portion prior to that is explained in 142.11b. This anything contained in section 30. More tax shall be paid on services under this act to the extent the tax was delivered of state services. The chapter 5 of the Finance Act 1990 deals with service tax. Jurisdiction to tax is still with the central authority. But the service tax tax can be levied under the state GST or under the GST. The effect of the tax. The first subject.
What is the finding now?
Based in the second 142.10, what's that entire thing?
Page?
Please, it's the eight. Who go into this? And addressing the other content
Yes.
raised by the RP, that the tax cannot be levied under CG previous standard. The notification value 4/2018, the date of time of subject. Number of notification issued to notify the class of the registered person is the tax right. Where it is issued to prescribe the time of subject. Therefore, the replace file on the upload not that space.
Is there no finding
There is
in the, there's no finding in the order that this supply was done subsequent to the appointed date?
and the notification 4/2018, the Lordship see, which has nothing to do with this. That's a GST notification which was issued much later to bring certain transactions back to the landowners. That cannot be brought to tax. There is a statutory provision in 142.10 specifically barring this. The Lordship should see the discussion on 142.10 is at page 69.
Yes. No, let us see.
Similar matter for service tax. One focus on the tax and JD.
Page?
The other service tax. Better one tax service tax.
Let us see. Now, the point appears to be determination of when there is supply. Their contention is supply has happened earlier to the appointed date. And the department contention is the deed of declaration will be the date of supply. It appears that is the stand taken, that the supply is effectively as in the deed of declaration. The deed of declaration is after the appointed date.
Almost after
They-
So the whole consideration part of it. Technical matter such as that. Stay has been granted on the very same. Or GST I get extension to the language. I didn't want to, I'm going to say, still type. We don't use any being on. I think the 30 days is started. Okay, because yeah.
When is the order passed?
I have to see why. The days is over, anytime you start. Also, my lord, that means that this next. This next, writing the future, you know, so this next thing. I don't any. I think those are like one of the problems.
Correct. But now we are on the point. Right, but we are on the point of when the supply has taken.
So 140.
But at page 67, the second last paragraph, therefore, at page 67, second last paragraph, therefore it is clear.
By my God, 4211 BH, what you got say, not sending anything section 30. God sees that section 30 that will have to do with liability to pay tax services. The point of supply, time of supply may not. These cases, is overridden by 142. They say the tax will fall under the service tax, irrespective of the fact that you have entered into the agreement after the appointed date. 4211B, that's why I said not standing anything in.
No, but if now, M. Kumar, there's a point in what they are contending, that is under section 13, under the chapter 5 of the Finance Act, if there is liability to pay, that is overridden by this. So if but that overriding is only to the extent that supply is after coming to force of this. So if now we have to determine whether at that point there is supply or at this. Okay, I noticed the contention. Learned senior counsel, learned senior counsel appearing for the petitioner submits that the supply in the JDA has concluded prior to the appointed date, and accordingly the appointed date full stop, it is submitted that the supply is concluded prior to coming into force of the Karnataka Goods and Services Tax Act 2017. And if that were to be so, in terms of 142(10), a question of invoking provisions of the KGST Act would not arise. It's submitted that in the assessment order, the point of supply, point of time of supply has been misconstrued by taking note of the deed of declaration, while supply has already been completed before the appointed date. Accordingly, it is submitted. It's a jurisdictional point that requires to be adjudicated. Lord AGA seeks time for obtaining necessary instruction and submits that the question of the threat of recovery for the present may not be there, and within 2 weeks he would get back with the necessary instructions and make a submission relating to grant of interim order. Accordingly, list the matter after 2 weeks while noticing the stand of the state. Yes. The Yes.
Item 12.
Only say that with the pleasure of heading the tax bench, is I always know that the lawyers will handhold me. They don't they don't start with the assumption that I know. So there is some sense of comfort.
This is what education is not. This material is required. But it is open to argument.
That's why whatever matter, even if I don't understand, I know that I can ask and I will be made to understand. Yes. Yes.
Assessment party. Assessment year and not 2014-15. If one is the facial revenue and not
Income tax. Council Shri Sanmati accepts notice. Directed to accept notice for respondent 1, 2, 3. Council Shri Madhavan Pillai is directed to accept notice for the 4th respondent. Yes.
One 48 should have been used. Before 31/3/2021, 6 years as per 148. Notice here was issued on 16/4/2021. And this is why it is because of the taxation other class amendment act. They might extend those periods, April and May. And also the observation Ashish Agarwal's case. Right? The notices to be issued under one. It's a matter where we got Ashish Agarwal's case. Was held that defense of section 149 will be open case. Whether the time limits that we adhere to are not. Considering this time limits, we got lots of stuff to see.
Just take me to the provision.
The provision. 49. Yes.
Is that order? When senior counsel appearing for the petitioner submit that notice dated 16/4/21 is beyond the period right under section 149. Submitted that under similar circumstances in identical factual and legal metrics, interim orders passed in WP 11246 of 2023. The order in the aforesaid petition reads as follows. Accordingly, in the present matter, so there would be an interim order of stay of
C1 to C3, D1 to D.
A, B,
C1 to C3, D1 to D.
C1 to C3 and D1 to D3. Respondent is at liberty to move for modification of interim order upon filing statement of objections. Do we tag this along with the? The matter along with WP 11246 of 2023 by noticing that the legal question raised is common. That Council Sanmati accepts notice for the respondent. Yes.
May it please, Your Lordships.
Nagar.
Item
Number
12.
11.
Hold on, please.
Make adjustment. Sanmati. Just one. Yes, Council.
Item 12 has been called out, my lords.
Yes,
May it please, Your Lordships.
you are supposed to file some amendment.
My lords, that amendment has
11.
already been filed
No,
in the last
11.
occasion.
This is seal number 11.
My apology, my lords. My apology. I am appearing in 12, my lords. My apology.
It's the matter. List the matter. Next. List the matter next week. Yes, next.
12. Arjun Rao, serial number 12.
May it please, Your Lordships. I appear to the petitioner in this matter, my lords.
Just 1 minute. Just 1 minute.
My apology, my lords. My apology.
Disposed of. Serial number.
Serial number 12. Arjun Rao.
Yes.
Number 12.
May it please, Your Lordships.
Yes.
In the last occasion, Your Lordships had directed the respondents to take instructions, my lords, because a very narrow issue is involved in this matter, my lords. This is a matter where there is an error committed by me in reporting and filing my returns, my lords. Admittedly, it's an error. There is absolutely no revenue implication, my lords. Instead of column A, I have reported in column B, my lords. That's the error committed by me. Instead of showing it as a B2C sale, I have shown it as a B2B sale. A B2B sale, I have shown it as a B2C sale, my lords. I wanted to correct that. There is a rectification possible, my lords. The only ground is that the time limit for rectification has lapsed, my lords. Lords, that this very issue, my lords, had come up before the Honorable Madras High Court, my lords, identical issue. And the Madras High Court directed the revenue to allow rectification because it's only a matter of reporting. There is absolutely no revenue implication in this, my lords. The tax remains the same, everything else remains the same. That was followed by a division bench of the Orissa High Court, my lords. The Honorable the Chief Justice directed opening, my lords. And recently, my lords, the Jharkhand High Court, in identical facts, has construed the entire scheme of the act and said that such rectifications should be allowed because these are not rectifications in that sense. These are errors in reporting which should be allowed to be corrected, my lords. And
Same. We'll ask him to. Now you just point out the facts.
lordships, here, my lords, the period is very important, my lords. This is, my lords, the initial period when GST was introduced for the first time in July 2017. Your lordships are aware it was introduced for the first time from 1st of July 2017, my lords. Nobody was aware of anything, my lords, including the officers, my lord. With great respect, if I make a statement, my lords, it was the initial period, my lords. And for the first time, a new law was introduced, which was going to affect directly or indirectly 1.3 billion of us, my lords. And therefore, there were initial systems, initial errors, etc., my lords. The period involved in the present case is, my lords, the initial period of July 2017 to March 18, my lords. the first period, my lords, for which, my lords, I have entered a turnover in my return, in my outward return, that is the monthly return called GSTR 3B, my lords, as 55 crores, my lords. That there is no dispute about the turnover, there is no dispute about the tax payable on the turnover, my lords. However, for reporting, my lords, reporting in my return, my lords, so that my customer, the purchaser, is eligible for credit, I have to report it as a B2B sale, B2B supply, my lords. That is business to business supply. Instead of that, my lords, I committed an error, my lords. The error is on my part. There is no, I'm not running away from that. My reporting error, my accountant, my lords, reported as B2C supply. That is business to customer. That is like end consumers like us, my lords. Like your lordships, or I go and buy a mobile phone, my lords. Or we go and buy a chocolate. These are B2C supplies, my lords, because the end consumer consumes the final product.
So this reporting
Lordships.
is at annexure.
Lordship, this is at annexure. In my return, my lords, my GSTR 1. Page 72 onwards, my lords. Running page 72 onwards, it goes up to page 116, my lords. It's my return.
Just point out to that error.
Yes, my lords. Yes, my lords. Page number. Amended P2B lords. Your lordships have column number 9A, 9B, 9C, my lords, in that.
Page.
My lords, this is page number. It's a running page number, my lords. It's horizontal. My lords, may kindly see page 88. If your lordships kindly come to page 88.
Yes. 88 also is blank.
Blank, my lords. It's all zero.
Huh? No, so okay, then you go, carry on. Let us see.
Lordships.
Carry on. Yes.
If your lordship sees annexure G, my lords, there I have explained this, how I have reported incorrectly and how it ought to have been corrected, my lords. If your lordships have annexure G, I have given a breakup, my lords, to
Yes.
show, my lords, that there is absolutely no revenue implication. This is only a matter of reporting, my lords. Has my lord got annexure G, my lords?
Yes.
Your lordship may kindly see the first, my lords. I have reported as original invoice as URD, that is B2C unregistered, whereas it was registered, and there I have corrected the taxable value and the GST amount so as to avail, so that the customer can avail credit, my lords. This was accepted by them, my lords. Whereas if your lordship sees in the very same chart, second amendment, my lords. If your lordship sees second amendment, that is not being accepted by them, saying that I'm sorry, sir, because this is beyond time. I cannot allow you to permit to rectify this. Because this is for the period December 17 and April 18. I cannot allow you to correct this, Lords.
You take me to the order, let us see.
Lordships. And whereas, before that, may I just point out, Lordships, in the scheme of the Act, I, as a dealer, I am required to file this returns monthly. Lordships, I am required to file monthly returns or quarterly returns based on my turnover. But as far as I am concerned, the petitioner before your Lordships, I am required to file monthly returns. Lordship, this error has happened in my monthly returns. Whereas, the law requires the dealer, the supplier, to file an annual return also, that is called the GSTR 9, which is the annual return, which is filed with the department. In that annual return, there is a provision which allows me to correct whatever mistakes I have done throughout the year and report it correctly in my GSTR 9. For example, if I have short paid tax anywhere, I can correct it in my GSTR 9. Or if I have paid excess tax, I can correct it. Or if I have reported some figures incorrectly or turnover not correctly, or I have to tally it with my audited books of accounts or audited balance sheet. So GSTR 9, according to me, in my respectful submission, is the final return. In that final return, I have corrected this. I have correctly reported this, I have corrected this error, for the period.
So let us have a look at the order.
Lordships, may kindly see the notice, Lords.
No, M. Kumar, now after he completes, if we can dispose it, I'll hear him. Use the mic. Use it. $73.5. No, correct, but now the point is that the period of limitation, they can't. So now the government advocate proposes that we'll keep the writ petition pending, will permit you to go before the authority, and in case any adverse order, then we can will keep open liberty to move this matter. He says the authority may consider it if in GSTR 9, if there's a provision, you explain it to him. We'll keep it open here. You go before him, explain it. If he ends it, there ends the matter. Otherwise, we reserve liberty for you to come back. We'll keep the writ petition alive, and we'll keep liberty for you to revive the proceedings.
Lordships may say that. Lordships may my only submission for my Lord's kind consideration would be, my Lords. Lordships may give them a direction saying that let them consider these judgments of your Lordships, my Lord. Because this is some, with great respect, my Lords, they should not say that since the objection in the notice is this only, that it is beyond time. And therefore, the authority should not say, I am bound by the time limit, and therefore I am bound by this. He is certainly bound by your Lordship's judgment also, my Lords. So let him consider that. And I will go back to him. Let him consider that. And if it is adverse to me, Lordships may give me liberty to approach your Lordships again and amend the present petition, impugning that order as well, my Lords.
No, correct. So the only point remains that if limitation, now if that comes up and he says, I can. You just take us through these Orissa and Jharkhand judgment.
Yes, my lords. Your lordships may kindly have the Orissa High Court, my lords. It's a division bench of the Honorable the Chief Justice, my lord, Justice Muralidhar. My lords, may kindly have that first. Shiv Jyoti Construction. Has my lord got that?
Yes, yes.
My lords. The petitioner before this court seeks a direction to the opposite party to permit the petitioner to rectify the GSTR return filed for period September 17 to March 18 in form B2B instead of B2C as wrongly filed under GSTR 1 in order to get input tax benefit by Messrs. Odisha Construction Corporation Limited, the principal contractor. My lords, identical facts if I may make a submission, my lords. Admittedly, the last date for filing the return was 31st of March 2019, and the date by which the rectification should have been carried out was 13th of April 2019. It is the case of the petitioner that the error came to be noticed after OCCL held up the legitimate running bill amount of the petitioner by informing it about the above error on 21st of January 2020. It is the case of the petitioner that thereafter it has been making request to the opposite party to permit it to correct the GSTR form, but to no avail. The stand taken by the opposite party is that once the deadline for rectification of forms was crossed, therefore no further indulgence could be granted to the petitioner. The fact remains that by permitting the petitioner to rectify the above error, there will be no loss whatsoever caused to the opposite party. It is not a case as if there will be any escapement of tax. This is only about the ITC benefit which any event has to be granted to the petitioner. On the contrary, if it is not permitted, then the petitioner will be unnecessarily be prejudiced. In similar circumstances, the Madras High Court in its order dated 6th of October 2020 in the case of Sun Daikin accepted the plea of the petitioner and directed the petitioner in that case should be...
Just one. Now, the assessing officer may not exercise power to condone the delay, saying under the statute I'm bound.
Lordships.
It has to be done by this court.
Lordships.
Now, yes. No, correct. So, if no, otherwise you get instructions. I'll keep it there. And then if the instructions are, there is some factual adjudication that has to be made at their end, then we can send it back. Otherwise, we'll close it here. What is the interim order you have sought for?
Lordships on the last occasion had granted the interim order that there should be stay of the proceedings, and that can continue, my lords, till my learned friend obtain instructions, my lords.
Because there are some aspects which you may require to. The interim order, interim direction made earlier. No, 12/7/2023 is extended till the next date. List the matter week after next. The respondent to get necessary instructions. Yes.
What would be the next date, my lords? My apology, my lords.
Yes, week after next. Week after next. Yes.
That will be 9th of August, my lords.
There will be some change. So we don't know how dates will be given. Let us see. Let us see.
Lordship, please. Grateful. I'm obliged, my lords.
Yes. This is the matter week after next. A request made on behalf of the respondent. Yes. In the same, yes, Sushal, same stage. Huh? Can be disposed of. And this is the matter tomorrow.
This 148 notice will be challenged. So, the reassessment notice wherein the section 149 1B below 50 lakhs. They're not putting 148 or my last, it's not available in the portal itself. It's survey across the province.
There is an interim order. Interim order earlier granted is extended till the next day. List the matter next week. At request made on behalf of the respondent. List the matter in the week commencing from 7th of August. Yes, Dilip, you appear in this matter. 16. Yes, yes.
Yes. Person who is not related diplomat. Diplomat is entitled to the report. That's the practice range over that. Diplomat who are entitled to appearance class. For the postponement of the India, the exemption. They don't have what they do. They claim to be a diplomat. Diplomat is appearance. Oh, all those documents were given at the time of purchase. The duty that is more like 60 lakhs, 60 lakhs. And I work for the conduct of the petition on better application. And it's modified purchases for lovely. Operation that is purchase the vehicle, which is currently is not. How does it lead to
Now, what is the judgment you are relying on? What is the condition imposed in this case? Differential duty, then bond, And then bank guarantee. So then what was the modification? So now, if the differential duty is taken care of, para 4 of the order, the court says you pay 50%, and for the no, correct. No. Now, so far as what is the differential duty now in this case? 62 lakh. So we can impose the same thing. Say half let him deposit. The other half, he has to give a bank guarantee and keep it alive. And keep it renewed till adjudication is complete. Now, whatever other action, he'll have to face the consequences, whatever. But so far as the tax, 50% he'll pay, 50% he'll keep the bank guarantee alive till the adjudication. That should take care of your interest. No, correct. But it can't be a penalty. What I'm saying, duty cannot be a penalty. Penalty, whatever in after adjudication, you are at liberty to impose whatever penal provision. But this is taken care of, and he gives a undertaking that he will ensure that there will be compliance of the eventual adjudication order. No, that may be so, but for that, no. No, correct. No, now, the question is for the condition imposed. That condition, he has to satisfy it now. That we cannot postpone. Now we dispose it off, and plus a personal bond that eventual whatever he will adhere to it, subject to whatever remedies open to him under the adjudication order. Yes.
In the origin of rule by the diplomatic rules. Here,
That is true. The petitioner. So whatever other action you can take. No, now, correct. Now we are at the stage. Provisional order is already passed. Other legal contentions, they'll keep it on. Let us see. No, that I will not enter into. Now I'll only limit myself to the conditions imposed in the provisional order. All other contention or proceedings will be kept open. No, it's okay. 100% is taken care of. 50 plus 50 bank guarantee. Remaining, it's open for both of them. Yes. Now that condition will impose the petitioner in the present petition. I thought for watching the seizure memo at annexure A and watching the provisional release at annexure E by imposing as regards the conditions being arbitrary and bad in law. The outside petitioner submits that the present petition is to be limited insofar as condition imposed in the provisional release. Outside submission is taken note of. The petitioner is stated to be a purchaser of a Range Rover Sport 5 SVR vehicle bearing registration number so and so, chassis number so and so, para 1. Stated that petitioner, after purchasing the vehicle, believing the representation of his vendor, vehicle was inspected and detained and seized as per seizure memo dated 16/7/21. It's further submitted that the vehicle is in the custody of the second respondent till date. The petitioner submits that in terms of the provisional release order, provisional release order at annexure E dated 29/12/21. 29/12/21. Conditions have been imposed, which are as follows. Reproduce order portion at page 30. Page number in control. Operative portion at para 7 at page 39. Last page of the order. Next. The counsel for the petitioner would submit that where similar conditions were imposed. This court in WP 6765/2022 has modified the onerous conditions by directing the petitioner to pay 50% of the differential duty and execute take out a bank guarantee for the remaining 50% and shall keep it renewed till final adjudication. It is further submitted that this court had directed execution of a bond as well, wherein the petitioner was to furnish an undertaking that he would pay the duty, fine, penalty as may be adjudged by the adjudicating authority, subject to the order being taken up before the appeal remedies if the same is adverse. It submitted that similar order may be passed in the present matter also. So, learned counsel Sri Amit Anand Deshpande has filed statement of objection. It submits that the manner in which the vendor of the petitioner has purchased the vehicle is objectionable, and that such transactions needs to be dealt with appropriately by imposing deterrent conditions. Heard both sides. Huh? It's further submitted that the alternative remedy ought to have been invoked. Next, heard both sides. Notice the order in WP 6765 of 2022. This court has imposed has modified the conditions of provisional release. Proves the conditions imposed. And it is noticed that the interests of the revenue are taken note of, not only as regards to differential duty, but also as regards the future liability, so far as execution of bond has been mandated. Insofar as final adjudication is concerned, it is always open to the authorities to impose, to take appropriate action without entering into the merits, when noticing that the continuance of vehicle in the custody of the respondent would not in any way further the case of the respondent, nor would be of any legal requirement. It would be appropriate that the conditions imposed in the provisional order of release be modified in terms of the modification as made in WP 6765 of 2022. Accordingly, the petition is disposed of as follows. The same order, Roman 1, the differential duty to be changed as 66 lakhs 28,215. Roman 2, execute a bond for 32,49,125. Wherever the word beneficial owner, it will be petitioner. Petitioner and Roman 3 petitioner. The petition is disposed of. It's made clear that the imposition of condition is in the peculiar facts of the case and cannot be treated as a precedent in other matters also. Yes. All contentions are kept open and the proceedings relating to adjudication can progress in accordance with law. Full stop. Anything else? Liberty is kept open to challenge, to address his grievance as made out in prayer A by way of appropriate proceedings. Yes. Huh? Let us see. Yes. So where is annexure? So where is the violation? Annexure F is the show cause notice. Annexure F is the summary of show cause notice. Yes. Yes. Page 83.
93. Yeah, 93. Yes.
Page 93, is it? Now this, which is this document?
This is my submission to each of us.
Annexure?
Section.
Now under 73(1), there is a provision for personal hearing. Huh? 74. KGSTI. Hmm. 35(4). Let me check. Yes. So now what has happened? He did not afford you any opportunity. Well, go to the order. The same. Page? Yes. So the time was granted.
As well as hearing. Fortunately, after the show, this I know. This email are not coming to my information.
Everything. Your request was made on what date?
6th.
6?
Issue date.
So now the order is passed, is it? So at the last stage, only for hearing, anyhow, everything is done. You can give an opportunity of hearing. People.
Yes.
Petitioner has sought for quashing of the order in 73-1, dated 17/6/23. It's sought for setting aside of the demand notice in interest and penalty at annexure J. Petitioner submits that orders passed in violation of principles of natural justice, and he may be afforded another opportunity of a personal hearing as requested to address his grievance. Attention is drawn to the submission to the show cause notice of the petitioner at annexure G, wherein a request was made to provide an opportunity of being heard. Such a request having been made in the submission at annexure G to the show cause notice is not in dispute. However, AGA appearing for the revenue submits by way of endorsement dated 6 June 2023. 3 days time was granted and that opportunity has not been utilized. Peruse, they reply to the show cause notice, which makes it clear that the request of personal hearing has been sought for. During the process of adjudication, in terms of section 75(4) of the AGST Act, opportunity of personal hearing is required to be made out. No doubt, endorsement dated 6 June 2023 does indicate 3 days time was granted. However, wordings of the said endorsement appears to be ambiguous and does not in so many words provide an express opportunity of personal hearing as sought for and requires compliance to be made good. Accordingly, extending the benefit of ambiguity in favor of the petitioner. The order of adjudication at annexure H is set aside and the order of demand at annexure J set aside. Matter is relegated to the stage of personal 3rd March, requiring response by SOP is at page
36. It's 36 years. What do you think?
so this annexure A, they gave you 3 days time.
Yes, sir. 4 days.
By 25/3.
Yes, sir.
Now under 148 AB, what is the stipulation? The 148
7
A.
days. 7 days.
Not less than 7 days. So then it has to go from that stage. The petitioner has a sought for correct. So we start from that reply to AB notice. Petitioner has sought to challenge the assessment order at annexure K passed by the respondent number 1, comma, the computation sheet at annexure K1, comma, demand notice at annexure K2, comma, penalty notice at annexure K3. The counsel for the petitioner submits that the notice under 148 capital A small b at annexure A was issued on 21/3/2022 with reply to be made on 25/3/2022. It is submitted that the said notice is defective as time that is granted is less than the time statutorily mandated under 148 AB, 148 capital A small b. It is submitted that once the notice does not provide sufficient opportunity, all proceedings thereto are required to be consequentially set aside. Third, both sides. Next, 148 capital A small b reads as follows. The statutory mandate is that notice cannot be less than 7 days. That is clear from the provision itself. In the present case, annexure A on the face of it has to be set aside only on the ground the time granted for replying to the 148 capital A small b notice was 4 days, as notice is dated 21/3/2022 and reply was to be made out by 25/3/2022. In light of the same, as a defective notice would vitiate the entirety of proceedings, though subsequent proceedings have culminated in passing of an assessment order. Accordingly, the notice under 148 capital A clause B is however reserved as affording a sufficient opportunity. Is however preserved while directing that the respondent give an extended time period for its reply. Considering the time spent before this court, it could be taken that the petitioner is now in a position to make out a reply to the 148 capital A clause B notice by court fixing an appropriate date in that regard. Accordingly, the petition is disposed of. The orders at annexure K, K1, K2, K3 are set aside, as also the order under 148 capital A D small d. Matters relegated to the stage of reply to the 148 capital A small b notice. Petitioner to make out his reply to the said notice within a period of 3 weeks from date of receipt of certified copy of this order. 4 weeks from date of receipt of certified copy of this order. All contentions are kept open. Yes. You appear in that also. Shall we dispose of that one? Number 32. Yes. No, what are the facts here? Annexure
A.
23 3. Yes.
And I replied even on 6 days.
Then it's a almost identical order.
Except that there is A. Here it is L1.
Annexure number is also same.
Section numbers are same here. Here, here are it's A. Here it is L. L1, L2, and L3.
The petitioner has a challenge. Assessment order. Annexure L passed by respondent number 1 dated 30th March 2023. The computation sheet at annexure L1 to demand notice at L2, the notice at L3. And counsel for the petitioner submits that the notice under 148 capital A small b at annexure A suffers from legal infirmity insofar as notice is issued on 23/3/2022 calling upon the petitioner to reply by 29/3/2022. It is submitted that the time of 6 days granted is contrary to the mandate under 148 capital A small b. Accordingly, it is submitted. If that were to be so, the notice being defective, all consequential proceeding requires to be set aside. Bitter, baki the same. Bitter, baki the previous order, same as it is. Conclusion paragraph. Accordingly, petition is disposed of. The orders at annexure L, L1, L2, L3 are set aside. Matter is relegated to the stage of reply to the notice under 148 capital A small b. Petitioner to take out a reply to the 148 capital A small b within a period of 4 weeks from date of receipt of certified copy of the order. All contentions are kept open. Note same reasoning. Yes. Release tomorrow, same stage. Yes, next. 20. Same. Yes, same. 22. 22. It can be disposed. We'll have it tomorrow. Otherwise, we'll have it some other day. Yes. Grant an interim order subject to deposit of 10% of the demand. Okay, let us see tomorrow. Tomorrow. Correct, but when you're coming end of the roster, you must also use. Okay, tomorrow. Release the matter tomorrow, same stage. Yes. And in fact, for listing a case, counsel, for listing a case, Ramohan Reddy had quantified it those days, some 1,600 and something or what. So that so much cost is imposed. Now that cost must have gone up. Yes. Yes. File good. File. What are the facts? On 9/8. Annexure. Annexure E. Yes. No, this is same SSC, different year. Which is that petition? 133 of that is released, not yet. Check. Check my. Don't worry. We'll have it tomorrow, and then we'll dispose it up. Release the matter tomorrow on top of the preliminary hearing list. Yes. Yes. The 7.5% you will pay in 8 installments.
How much? Because already commissioner, he himself gave a limit.
Page. Yes. No, correct. Now, yes, anyhow, he has given 8 installments, isn't it? Let him pay now. The 8 equal installments of. No, correct. How many, what is the gap?
Simply.
30th of each month. Yes. Each month. It's hard for. Issuance of writ of certiorari. What's the order? At annexure A. By application of stay was disposed of, imposing the conditions to deposit 20% of the disputed amount. Balance amount was required to be paid in 8 equal installments. The counsel for the petitioner submits that petitioner's financial position being in dire straits, petitioner requires indulgence, relaxation in the conditions to be imposed. And counsel for the petitioner submits that the balance is a balance of 20%, isn't it? The counsel for the petitioner submits that one. No, correct. What I'm saying, the counsel for the petitioner submits that the condition imposed the order at Annexure A has the effect of directing the petitioner to clear the now one inch. Yes. Next, counsel for petitioner during the course of the proceedings has submitted that the order at Annexure A can be reworked by imposing the following conditions. Pencil mark reproduce. Next. Hearing the matter for some time, considering that present proceedings are only against the order of stay that is granted, and the proposal by the SSC to take care of interest of the revenue matter could be disposed of by directing that there would be stay of the balance of disputed demand till disposal of appeal by the CIT within bracket A, subject to the payment as below. 7.5% of the disputed demand be paid within a period of first 7.5, how much time you will pay? Correct. How much time?
688. That will be good 8 okay. 6,55,836 for first for 8 months.
Demand after deducting amount of 19,07,890, it would be 52,46,688 to be paid in 8 equal installments. Each installment to be paid on or before the 30th of each month. Accordingly, the first of the installment will be paid. Yes. Which 30th we are now? Which 30th is there? Huh? Yes, definitely 23. We are on 30th of. Huh? So correct. First installment you pay early. When will you pay? First of the installment to be paid by 30th of July 2023, and the remaining 7 installments. And the remaining balance to be paid in 7 equal installments, and each installment to be paid on or before the 30th of each month. As regards the balance of 12.5%, which would make up 20%, the personal guarantee of one of the directors of the company to be filed with the authority within a period of 2 weeks from receipt of certified copy of the order. The details of the director and the standing in the company must be accompanied by official records. Official records. Full stop. Accordingly, the order at Annexure A is modified in terms of the order made above. Accordingly, petition is disposed of. All contentions are kept open.
The last line. There. Concerning the work, there is a strong limited mention made in the assessment document. And submission is that he is the officer of Municipal Commissioner of Income Tax, who is above the rank of appellate authority. Uninfluenced by this order, the Municipal Appellate Authority has to pass the order. Uninfluenced the order of uninfluenced with the observation made in the improved order.
Needless to state, the observations made in the order at Annexure A are made only for the purpose of disposal of the application for stay and cannot be taken to be a conclusive finding as regards the merits of the matter. And all contentions are kept open during the course of adjudication.
Right?
Yes. Just only. That time we had adjourned it. Yes. Okay. Yes.
Section registration obtained by means of fraud, willful misstatement or oppression of fact. So these three are three different set of allegations. For that, if they become the they propose to state out the relevant factors whether there is a fraud or willful misstatement or oppression of fact. So they have made it reproduced. And then by passing order, they stated different. It's on page number 15.
Page
15. Saying that the person does not conduct any business from the declared business. Okay, the supposed below to mention that the order has traveled.
yes. Show-cause notice for cancellation of registration. Yes.
Second particular.
Person one.
We provided all the documents of the same one, reason why we have issued them in 2000. Here the case was proposed to have taken this case on it, but has not connected with the except for even 50 branches. And well, this very same person in the very same time card has got a registration in Delhi, and global interface, and goods are transported from petitioner's place from Chikmagalur to Delhi without document. Whenever there has been interception, petition number is a penalty and takes a vehicle. Even today, number of registration are free of the latest version, which was on 60 in the what are the
Then we
have been also on this person all the documents we provide to them. Then we pay to them, we must taking out. Again, for another
no, just one, just no. So
again, the station. This is not, we have pretty statements from person by rather than saying that they have not seen any person conducting business here. And from the day it was started, there were only 35% that just started.
So annexure D will stand revived. Then you will be.
We are not because the options that are there. Even in cases where the institution
So in support of annexure D, material to which he is required to reply will be furnished. Would be furnished. So now without entering into the merits.
Now, since the day of issuing now, since they did not give the details, I have not been able to ask them. Let's first of all, this open needs to go. If they want to issue a press they can anytime issue any like but so far as resorting of open to this government, it is bad enough. But we highly have these two orders of very high. Just page number, para number space. Similar show what only was in that para 6. the reason indicated in the Shopper notice about positive action, it is under section 29 for the.
No, correct. Now they'll make good that defect.
I'm not disputing that.
No, that will be done. That will be done. Will no, that will be no, that we will do. That will allow. No, that no, correct. So now no council. Now we will restore the registration, but we'll restore annexure D. They will give you information. Proceedings will go. Yes. Let us see. The petitioner. Sought for the side of the order of cancellation of registration. The registration form GST REG-19 issued with a reference number so and so. Details at Roman 1 of prayer call. Dated 12/6/2023. It is pointed out that the notice, because notice at annexure D mentions that the ground for cancellation would be under 29 subclass 2 subclass E on the ground that registration was obtained by means of fraud, willful misstatement or suppression of facts. It's pointed out, however, that the order of cancellation is on the ground within inverted comma rule 21 within bracket A hyphen person does not conduct any business from declared place of business, close inverted comma. Accordingly, it is submitted that the show cause notice and the order passed are at variance. It is also contended that the show cause notice at annexure D is cryptic and without furnishing further information, petitioner would not be in a position to meaningfully reply to the notice at annexure D as the grounds mentioned when individually taken require specific reply. Next, AGA submits that the petitioner upon instructions that there are discrepancies insofar as the petitioner is concerned, and however submits that those are matters on merits, but the show cause notice at annexure D may be revived, and to enable the petitioner to make out a meaningful reply, all information would be provided in support of the show cause notice at annexure D. It is submitted that such course of action is warranted in light of the material available with the revenue as regards the petition. Next, heard both sides. It may not be appropriate to enter into the merits of the contention raised by the revenue regarding the standing of the petitioner at this stage. Suffice it to state that order at annexure A dated 12/6/2023 is passed on grounds not made out in the show cause notice at annexure D, and on the sole ground, order at annexure A is set aside. However, the show cause notice at annexure D would stand and subject to the condition being imposed by this court. The respondent revenue to furnish material in support of annexure D to the petitioner upon his appearance or wrong? Upon petitioner marking his appearance before respondent, before the commercial tax officer, before the commercial tax officer, before the respondent on on 5th of August. Subsequent, all contentions are kept open. Accordingly, petition is disposed of. No, once annexure A goes, it will stand revived.
It's not that necessary exercise.
No, but that you must make a request there, keep it open for them to consider.
It's given all the resistance cancelled on merits. Automatically everything will be and then so at least my registration can be
Yes. Though learned counsel, though learned counsel for the petitioner submits that by virtue of the order at annexure A being set aside, order of suspension requires to be revoked. However, in light of the contention raised by the revenue, it would be appropriate to direct the revenue to dispose of the proceedings within 1 week from receipt of reply to the show cause notice. Position of such time condition, timeline would take care of the interests of the petitioner as well. Accordingly, petition is disposed of. I'll have it released at the earliest. Yes. 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 The Himkumar instructions are completed. Yes. Page 12. Yes. Yes, May. No, but you are irregular is what they're saying. Previous, you are irregular in filing your returns is what they're saying. No, they're saying not on one, many occasions you are irregular. For 6 months, they have not filed. Now it can be revived subject to some cost of it. But you could have gone before the authority only. You could have gone before the authority itself. Why have you come to this court? That time is also. But now some penalty is collected from them or how? No, so now what is the order to be passed? Order of cancellation will be set aside. Yes. Subject to no condition. We'll take care. Yes. The petitioner. All that is okay, but his instructions are he should not have made such allegations against me. Else to whatever you said, they have no serious. The petitioner. For that, Shivyogi Swami is responsible. The petitioner has sought for setting aside the order passed by the second respondent at Annexure D. And has sought for issuance of writ of mandamus to direct the respondent authorities for restoration of the petitioner's registration bearing number so and so at prayer B. the petitioner, it is seen from the order of cancellation at annexure D, that the registration has been cancelled on the ground. So where is the ground at annexure D?
Cancellation at Annex to D that the registration has been cancelled
On the ground that no reply to show cause notice has been submitted. It's further stipulated that there would be cancellation of registration with effect from 28 to 2023. After hearing full stop, it is noticed that the order at annexure D is preceded with the show cause notice, wherein observation made was that the petitioner had failed to furnish returns for a continuous period of 6 months. Next, after hearing the matter for some time and noticing that the time available under the statutory scheme for seeking restoration of registration has expired, taking note of the reasons made out on the basis of and the submissions in support of reasons, it would meet the ends of justice by setting aside the order at annexure D and restoring the registration. The bona fide lapse, the submissions made in to the effect that there was bona fide lapse requires to be accepted. Consequent to setting aside of annexure D and restoration of registration number so and so, the petitioner to file accordingly, matter is disposed of in petitioner to comply with all other statutory requirements. All contentions are kept open. Yeah. Accepts notice for the respondents. Yes. 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 For the petitioners filed a memo which reads as follows. In light of this, which reads as follows. Next. Accordingly, petition is dismissed as withdrawn. Insofar as liberty sought for, no express order need be passed, as if the same is permissible in law, petitioner could do so and does not require any express order by this court. It's also to be made clear that the court need not pass any order on liberty as prayed for, as that would be the starting point of fresh litigation, and accordingly, such a liberty Accordingly, no further orders are required. Yes. It's the matter in the second week of August. Undertaking earlier recorded on 12/7/2023 is extended till the next day. Who's R2? Notice is not under the R2. Huh? R2. Who appears for CBDT? Not council. Takes to appear for the second respondent. Is the matter after 2 weeks. Where is Jivan? You are the contest. You are the contesting respondent. Just wait. No. Now, is the company under liquidation or what?
Yes, sir.
Then, what is the procedure? Who is to represent the company? It's under liquidation. Earlier, it was the official liquidator. Then, how can you continue proceeding? Then you have to. No, you have to produce. You have to produce records from the ROC regarding current status of the company. You cannot go ahead without that. That is there, madam. No, correct. But we don't know what is the legal standing of the company as on date. Whether official liquidator has taken it over or not. Only after you place that material on record, we'll be able to take it. We'll have it next week. Next week we'll have it. Correct. Deal is the matter next week. You find out and make sense. It's the matter. Now let them place it on record. 29. 29th, list the matter in the week commencing from that list the matter in the week commencing from 7th of August, 29. No, correct. Nothing will happen then if it's in the liquidation. We'll have to take find out what is the legal status and file it. It's the matter next week. Yes, next 30. What is this matter? List the matter week after next. Next, that requires some hearing. So you tell the interim order earlier granted is extended to the next date. List the matter next week. Week after next. In the week commencing from 7th of August. On account of what is the matter? Excess refund.
Yes.
50 of
Excess refund. There's no charging provision, which is enabling provision which enables the department to pay interest. It will not provide the inserted extra. Once it's 2021 not.
No, but-
in nature.
no, correct, but then correct. But now this matter will require some hearing because it will have implication in other matters. No, so my point is, if it requires an adjudication on that, you complete your pleadings. We will see what interim order and then let it be heard. Suppose we were to pass something, it will definitely have in other matters also. Huh? So then you file your pleading. That will consider. That will consider.
Yeah.
So you are seeking stay of which are also subject to payment of. Where do you get that? $132. $136. Now, correct. On this, you'll have to pay some interest. The rest will see. Huh?
already credit, which is lying with them. So extend the work from the day one. I don't clarificate to nature. Section itself. It's not the computing thing is after you are available in the somebody credit.
Okay, let us. There would be stay of stay. No, that they'll pay. There will be a stay of. No, you just take me to your interim prayer. 1 minute. Just take me to your interim prayer. There would be there would be stay of the order at annexure L and M, subject to the petitioner paying an amount of 1,36,05,757 within a period of 4 weeks from today. Yes. Statement of objections to be filed by the respondent within 3 weeks. Who's third respondent? Joint counsel. See, Mother Pilla is directed to accept notice for the third respondent. Yes.
My lord, sir, this serial number 30, my lord. Serial number just passed over, my lord. Serial number 30. If my lord.
We have extended the. We have extended the.
Yes, ma'am.
We have
If my
extended
lord
the
permit, from my side, I am ready, my lord. If my lord is free in the afternoon, my lord, I can come and argue, my lord, at the discretion of the court, my lord.
I've adjourned because it requires something. 33. Relist the matter tomorrow in the preliminary hearing. Yes.
34. Yes.
I request list the matter next week. Yes. Week after next.
35.
Just 1 minute. Right of the explanation made, office objections are kept in abeyance. Yes.
Some orders that pass, they are directly in some cases.
Just 1 minute. Just one. Commissioner of Central Tax. Council. Niralji is active to accept notice for the respondents. Let him take a survey copy. Let him come and pass over. Pass over. Yes.
36.
Sanmati, you appear. has to be stayed. In light of the order of stay granted in WP 1 of 2021, there will be an interim order of stay of nature A, B, and C. A series, B series, and C series. Respondent is at liberty to move for modification of the interim order upon filing statement of objections. List this matter along with WP 8031 of 2021. Yes. A series, B series, C series, and D series. Yes. Correct. Yes. The office objection is kept in. What about the other office objections? Still some others are there. Affidavit. If the office report doesn't say that. No, affidavit it says is not sworn to. So all the other office objections are clear. Light of the explanation made. Office objection. Serial number 1 is overruled. The office objections are stated to have been complied with. Office to verify. Who appears for the respondent? Commissioner of Commercial Tax. Here accepts notice for respondents 2 to 4. 1 to 4. 2 to 4. Let them to get instructions. Let them get instructions. You serve a copy, let them get the instructions. Now he must have a copy in his hand. It's the matter next week. Now, what is it you say? Let us see if he says, what is it covered by what? Just make a mail. Let them have a look at it. Let us. This is the matter next week. As we end the roster, we become more careful. Yes, next. Yes. Yes.
There is some very good
34.5. That is self-ascertainment. Now this is to be done before. We'll continue at 2:30. We'll continue. So Krishna, we'll have it on Friday.
Mm.
You represent, that is the landowner. So what is the settlement?
Once again, the matter is demanded in the court. Hearing them an option. Now, the society comes forward saying that we give you 48,000 square feet. In the very same, and it's 45,000. Accordingly, they are giving up the portions of the property. Settlement, because they cannot go up the other. GPA order of the petition. GPA is also present.
Ramachandra Reddy is the GPA holder for the petition. The respondent number 4. Who's the president? It is signed by the president and the board of directors. The petition was filed to quash the preliminary and final notification. The said writ petition, both respondent, the contesting party, beneficiary, the beneficiary of the acquisition. During the course of proceedings, joint memo had been filed. It is submitted that matter has been settled in terms of the joint memo. Terms of a settlement are contained at para 4, which reads as hereunder. Petitioner is present through his power of attorney holder. The president of the 4th respondent is present, as also the directors Present. They're present. You just call out their name. Nine of them have signed, isn't it? 9 of them have signed. 9 of them have signed, isn't it? Some of them. The secretary, what's his name? Balaji. Secretary of Society, Balaji is present. And and identifies the signatures of the directors. Light of the same. Further adjudication does not arise as the grievance amongst the contesting parties has been settled. Accordingly, petition is disposed of as not requiring adjudication while recording the terms of settlement. Settlement ಅಂತ ಎಲ್ಲಿ ವರ್ಡ್ ಉಪಯೋಗಿಸ್ತೀವ / additional compensation. Yes. Yes. I can't hear you, Council. You have to be louder. Correct. Now we are at the back end of the roster. So tomorrow, day after tomorrow, the last 2 days. Let it come next week. We'll direct it to be posted next week. PAN Aadhaar link. Why should it come before the tax roster? So that is a stipulation generally, isn't it? PAN Aadhaar link. It will not be a matter only limited to tax roster. Only consequentially tax. Roster you have to check. Huh? Roster you will have to check. Aadhaar. Tax roster. No, that is there. No. That you can verify which roster. Correct. You can do it. You can get a copy of the petition, show it to him. Just have a look at it. Yeah, have a look at it. Just share a copy of it. You were mentioning under 75, 75.4. 75.4. Now, before the 74.1 is it? They must give an option. They must give you an option. That's a procedure. Rule. Then you can exercise rule 142 1A, is it? No, even under rule 2, sub rule 2 also. 142 sub rule 2. Yes. Yes, Jeevan. Yes. Yes.
Officer, officer,
15-10-2020.
discretion was have been exhausted before issuing a notice and then fine. In our case, we have the amendment dialogue. That's what we wrote that. He was not protected from the word of the deposit. Before issuance of the notice, on his own affected. Options were there. It's not that the Lord only on issuing this situation and only then we should correct the tax. Even on his own affected, also he would have done it.
It is now not open, is it?
Now it is not open. After seeing certain open. Amendment based on this amendment by deciding to base of capital. But the rate of tax is 15% of the tax. Considering 3 days
Paragraph.
abstract this in volume. Because the last of the time, I don't know if any of us have that. 5%. 8 provision, my lord, the amended provision has been considered by the honorable lord. Honorable tax may. The same provision has been amended by the honorable lord.
Para 4. Yes. So otherwise, we can do one thing. We can say that we can permit him to do it, subject to the outcome, and stay further proceeding. Let him do it. Let him pay. Let him do self-ascertainment, and let him do the self-ascertainment exercise, and we'll see.
Yes, my lord, identification will not enforce the recovery. To the result of this. I think your lawsuit out there.
Page number. Page 14. Yes. Yes. Just this one. Just one.
Okay.
Taking to the effect.
Stage.
Correct. Correct.
That 82 A section 74 5 that proceed. Not enforce the recovery number.
It is. Read para 24, is it?
Fail to comprehend the information. Department should inform the owner. He will pay the balance. Then provide the department.
So what I'm suggesting is that now, no doubt adjudication is going to take place if the show cause notice is given. Now, if he were to resort to 75(4) on his own and file it during the pendency of the proceeding, which would be subject to the outcome. And in the event, eventually, we were to allow it, then he would have already done 75(4). Suppose the petition is rejected, then it would be subject to adjudication. Now, what is the interim order now you are seeking? Paragraph? So this judgment is also after the amendment.
So what are the those intimated by the which one thing say AR may not accept. Once he accepts it, there will be a confusion. Over if he does not accept, there is a being on the right here. Next course of action follows is to open up the act as a deep progressive change. Because before one more thing, independent from we have to take a while. So there are a
We can do one thing. Now, suppose we permit the department without prejudice to the pendency of these proceedings to issue DRC 1A. Let him do his ascertainment. We'll have it after 2 weeks. You finish your objections. Meanwhile, if they self-ascertainment, let him do it. That would be subject to orders to be passed. Let him ascertain, let him pay, whatever it is. And then we'll have it after 2 weeks. You file your objection and get ready with the matter. No, correct. So we will not enter into 74(1) for the time being. Anyhow, if they give DRC, no, then we will grant an interim stay, but you show your bona fides and deposit something. If according to you, you would have done self-ascertainment, we'll give you time, but you show your bona fides and make some annexure. No, we'll grant an interim order, but we are saying you make some deposit. If you were to do self-ascertainment, some amount you can get instruction, we'll have it tomorrow. It will save you to show your bona fides regarding self-ascertainment. Get instruction, tomorrow make submission, we'll have it tomorrow. Make some deposit, we'll grant it tomorrow.
Now it will take all the the entire line. There is no point in giving 74(5).
Correct.
Now, if there is some liability of willing, the ascertain by the officer, no, we are like, officer, we can discharge.
Yeah, correct, sir. No, so we'll impose. We'll impose some. No, so we'll impose some conditions. How much deposit? How much deposit? Okay.
Cannot be decided right now.
What is it?
It cannot be discussed right now.
Correct, but only to demonstrate some bona fides, some ad hoc amount to demonstrate that you are ready to go the way of self-ascertainment. You can suggest. We grant an interim order, condition on some deposit that you can suggest. Yes, yes. Yes, we'll have it tomorrow. List the matter in the preliminary hearing list tomorrow. Now, the only point Jeevan is making, which requires some consideration, he says that that amendment that is now carried out to correct, but he says the word shall has now been substituted by word may, so we can't make it, we can't interpret it as mandatory even at this point of time if a notice is issued post amendment. Anyhow, let us see. But you get instructions on some deposit. Tomorrow we'll pass on. Deal is the matter. Tomorrow in the preliminary hearing list. Yes.
39. Sri Hari, 39. Right?
Appearing for the petition, my lords.
Yes.
This is a writ petition challenging the assessment order, my lords, passed by reassessing the capital gains that had already been assessed by the very same respondent.
Just 1 minute. Just Third Council Sanmati accepts notice for the respondent. You serve a copy on him. We'll have it next week.
Please, my lords.
The consideration of interim prayer is kept open. This is the matter next week.
Please, my lords.
Yes. Give me that interim order.
After passing the order, within 15 days, garnish the order. I think the order will issue to my clients, two of the clients, 4 years. That's why I spoke to the report. The date, even passing the order, the appellate authority to garnish the order with the correction. Like if I garnish order to be.
Third Council, G1 accepts notice for respondent 2 and 3. AG accepts notice for respondents 4, 5 and 6. Emergent notice to respondents 7 to 11. Third Council, Madhavan Pillai accepts notice for the first respondent. Now we'll have it tomorrow. Have a look at that, whatever it is. Relist the matter tomorrow. Office objections to be complied. Yes.
Okay. This is 27 to 2023. This is E-38. Yes, taking charge on 5/7/2023.
Income tax. So transfer.
Order is 27 to 2023. This is 27 to 2023.
Page
38.
order is passed after this. Yes.
After what is this? 11/7/2023. Point.
We'll have it tomorrow. Fine. Only point. See, Mahesh catches hold of only such points. He's saying that as per annexure E, he is transferred on 27/6. And the order is passed on 11/7. So if he's transferred, that you find out whether he continued and handed over charge later or whatever. So page 40.
Then ensure that operator transfer shall remain with the operator service on market for 5 times. Assuming now it is on 5 times. The outer limit. The input order is person 11/7.
We'll have it tomorrow. Find it. You need instruction.
Civil protection is on.
Petitioner. Senior counsel appearing for the petitioner. It's that the officer who has passed the order at annexure
Election A dated 11 July 2023.
annexure A on 11/7/2023 transferred
7 June 2023, page 38.
as per the order dated 27/6/2023, wherein his name finds a mention at serial number 11. Then her name finds a mention at serial number 11. It is submitted that the outer time for reporting to the transferred place is
5/7/2023.
as per annexure
E.
is 5/7/2023 as per annexure E. And that order has been passed subsequent to such date on 11/7/2023 at annexure E. Accordingly, it is submitted that the order or notice, this one,
Order of prosecution.
order at annexure A is one without jurisdiction. Subject to further consideration, the order at annexure A stayed till the next date. This is the matter week after next. That council Sammati accepts notice for the respondent. Statement of objections to be filed. Yes.
Type copy of petition. Type copy of petition CAG. Thing is quite clear.
Office objection is kept in abeyance for the present. Yes.
My lords, 42 I appear on behalf of the petitioner. This matter has been listed for consideration of our IA number 1 of 2021. So if my lords were just to have page 36 of this IA, where the order of 18th of July 2019 was passed by this honorable court.
Now what we could do
My
is
lords,
we'll allow the IA
very
and
good.
fix a date.
Very
We'll allow
good.
the IA.
That's all that we are asking for.
One of 21 is allowed. Taking note of the submission made. This is the matter in final hearing list in the week commencing from week commencing from 21st of August.
Very grateful, my lords.
Serial 35. 13.
You would like to do this. Okay, no. After- Yes. The counsel for the petitioner admits that in WP 3529 of 2022, interim order has been passed. The factual and legal matrix inside the petition is identical to the present one. Order that has been passed in WP 3529 of 2022 reads as follows. Like the same, would be a direction for the respondents not to take any precipitative action against the petitioner. List the matter along with WP 3529 of 2022. Council G1 accepts notice for the respondents one and two. Yes. It's the matter in the week commencing. You want a date? It's the matter on 9th of August. It will be a Friday. Take it on a Monday. Friday, we don't know. There may be benches. 16th. Yes. It's the matter tomorrow in the preliminary hearing list. Preliminary hearing list, it will reach. Yes. Interim order earlier granted is extended to the next day. Day number 7. Okay. That requires hearing. Any disposal matters I'm having tomorrow. I've appointed amicus. Correct, but it has to be heard because it has implication in other matters. Let us see. Next week, we'll have it next week. I've appointed an amicus, he will also assist the court. Mahesh knows, I don't know. Correct. So he will assist the court. So we'll have it next week. No, it requires some consideration. Huh? No, but the legal position requires some time. Otherwise, we would have disposed of it. We'll have it next week. Wherever interim order is there, it will stand it. Then we'll have it tomorrow, let us. P6 release the matter tomorrow. Yeah. The orders list. The number? Entry number 50. The interim order earlier granted is extended till the next date. Seal number 15. What's the matter? After 3 weeks. Yes. So that's okay. That's okay. But there was no communication from somebody. So that's okay. No, that's okay. That's okay. No, that's okay. No, just wait. Just wait. So what we had last time decided. I think we'll, if you don't mind, in the Sandeep, in this, which is that matter in which you appear, your matter, Raghuram, your matter is in which there's one matter in which yours. In that we can ask somebody else to appear in that one matter. We can ask Sandeep in that because. No, just wait, we'll come. In that you just because some submission was made, so I didn't want that to. Yes, so now last time what we had decided, first 10 matters we'll take, isn't it? So in the first 10 matters, which first one? Yes.
10 convey to them. In which I could not have visited him, and he also did the before. And even if because in my particular case is very difficult. One of the case, readings have been completed, that's the second case. And the rest of the 4 other cases, the readings are yet pending, and instructions are yet to be sent to the department. In regard to this, some of the commission that a date for next week, maybe first second week of August, then I will conclude my arguments in these cases, including the.
Yes, we'll take up those matters where already pleadings are there. So if the legal position and stand is similar in other matters, then we'll see, we'll take a call on it. So we'll go serial wise, we'll take a call. So the 57, 11154. Yes. Yes. Now, what I was thinking, now in these whatever 10 matters, all of them may not be ready. So we'll see what happens. After some time, we'll take it up. If it is okay with you, unless you have some. When do you want?
Adjourned.
You appear in that other matter, Ganesh's matter. No, Ganesh's matter. Friday. Okay. So then this will have tomorrow. Huh? Yes, yes. We'll have it at 2:30 tomorrow. Huh? You have concluded. You will file a synopsis later, is it? Yes. We'll have it tomorrow. So 58, this is the matter at 2:30 tomorrow. Compilation. Compilation. Yes. But let us see what it is. Under
unconditionally accepted the notification 25 marks. Well, I did show you not that came into X. First of all, you cannot so the case where the education may not. The negative is 14 by 2016. The period of this is 15 and 16 up to March 2016. Then my lord, please come to in the petition, page 106. No, to 107 will be read.
note.
Not 6 is the negative list. Then the note my lord 107. A lordships the bottom.
Yes.
Created by Finance Act 2016 with effect from 14/5/2016. Prior to submission, clause will read as under services by way of preschool education of the highest education is part of curriculum for obtaining qualification. Education is part of the approved vocation. This was all in the negative list, not subjected to tax, all as not even recognized as a service. That's to say. After 14/5, my lord, they issued an exemption notification for this
Now the notice is issued for which period?
period is prior to this. Prior to 14/5. 2015, 16 is the notice of that.
In their notice, they what is the service they are?
Let's first see. They don't say what is the service. They simply set out. This is the 26 years income of 11 crores reported by you. What do you have to say? That is how they start. And my lord, this was the COVID. We told them we are primary institution, Bangalore. You have to wait before we issue the notice. They did not wait. We issued the notice. We filed not one free replace. The order, they have made up their. The order may not, he simply sets out that yes, you are a charitable trust, you are for education, etc. You are not, he doesn't even advert to the replace. He simply skips the replace, goes ahead and confirms the. That I will show you a lot. Portion of the order itself. See my lord, how they have gone about this case. How exactly they gone about. Come to this, I showed you a lot when I was earlier arguing this matter, but it must be the intimation from this managed. Enough of submissions which we made by not respect. When we issue an intimation, you should have done some homework because you can ask only for specified information. This, my lord, that what this? We gave it to a meeting. Non-payment of service tax of financial years 15, 17, 18 up to June 17. Check out. The effect from 1/7/2010, all services those listed is 15/16. Starting with service tax in terms of provision of 15/16 thereafter. Now the relevant income tax records made for the financial year appears that there were substantial services, but have not paid a short paid service tax. It's 11, 61, 66, 35, 1. You are requested to submit within 3 days of the same reconciliation statement. It also says it may be noted the above mentioned information are being called for under section 14 of the Central Excise Act deal with the Finance Act. I had shown your lordship section 14 talks of only specified information to be called upon. I make a roving inquiry to Allahabad saying that there is a difference to produce all the documents. So virtually they are saying here, my lords, you produce a reconciliation. whatever we are. Of this, I had said that. Page 86, section 85.
No, but now these notices, even G1, even if we were to take the notice at annexure E, what is it that, what is the service pursuant to which they have derived income at least must be stated.
Not in the order passed in this case, doesn't say so. Please see the operating portion of the order. Leave aside giving the notice. With the order, my lord, please.
Annexure?
The connection B. Just see, my. I ordered that the activity. Please come to page 66, my lord. 66. I ordered that the activity carried out with the notice at the bottom order. The taxable service in terms of section 65B40, 65B51 of the fact. What service I do, what I don't do, nothing is discussed. Then my lord made a specific reply, and he himself records it saying that yes, you are a charitable activity. My lord will see my reply check. He records it in the order. He also says another two submissions there. There are 11 the lord.
Yes.
Notice in the written submission dated 21st June 2021 reported the allegations made be seen as vague, incomplete, and unsustainable. Stated that they are a registered charitable trust engaged in providing educational medical service and carrying out religious activities. All three of which are exempt. Now, he doesn't take this into account. Please come to para 11 and 12 on next page. Page 59. Personal hearing. Notice he was given an opportunity for personal hearing on 4/11/2020. Also duly authorized by appeared and made a written submission dated 4/2022. Then my lord, para 12, he says another opportunity, another written submission dated 22/11/2022. After this, in his discussion and findings, my lord, he doesn't refer to any of this. The contrary, my lord, the para 17 lord. What is it? That is at page 63. Only thing he says at para 17, page 63, my lord.
Yes.
Further, I find that the notice has not submitted reconciliation statement to call for the officer by email dated so and so. The era of self-assessment notice you ought to declare the true turnover and assess the correct tax liability, declare the same. The statutory returns mandated to be filed. The absence of any documentary evidence submitted to the notice before the issuance of the true notice. And it can conclude that the notice had indeed suppressed the true transaction effected by the payment of. And it goes ahead and taxes. Also, my lord, you see at page 64, he says, this one. Well, 11th line
Page.
after section 67, page 64.
Yes.
The lordship comes in the section 67 somewhere at the gate. After that line is at the extreme right, thus the amount received the noticing of the service provided, which is neither exempted from payment of service tax under any notification or falls in the negative list of services in terms of section 60. They have made up their minds in passing such orders. They don't consider the reply. They simply take the amounts, confirm. This is the manner in which my lords, all the orders are.
Now, in which of the matter pleading is complete? Which of the matter pleading is complete? '57. So let us. Now let us say we'll take up one which pleading is complete. Now the broad framework they are saying is similar to all matters. So let us take that where pleading is complete. Let's have a look at.
Classification.
Yes. Sir.
Classification you see, you will know where it is. Which head it falls.
Again, 57.5. Six. 52 point.
My matter. My matter. Reading the class, I think told that already. I told that.
Let us see what is the stand you have taken.
The income that is shown by making the income tax returns, that it falls under the category of the C. The clarification was
So the argument made was that the notice is styled as a show cause notice. That cannot be given as a matter of course, that must be preceded by an inquiry in terms of provisions of the Central Excise Act as applicable to service. And that blindly you can't ask for information as fishing for information unless the notice contains some application of mind that you have applied your mind to the service that they have performed, and you hold that the service that they have performed does not fall in the negative list, nor it is exempt, and then you can call upon him to give information, failing which the whole proceedings must go right from the inception. What they are saying is, suppose it is exempt, suppose it's in the negative list, you must apply your mind and say it is not exempt, it is not in the negative list. Hence, there is some we need clarity. You can ask upon him to call. At least that much application of mind must be there. Is what they're saying.
Then, as I requested that as the observations made last week, I learned about the observations, and that is how I'm today listening for your lordship.
So that means so no, that's okay. That's okay. Now, then, which is the other matter in which pleadings are done? $57.5. 57 point. Yes.
12.2, lordship, please come to this. Annex B, page 0.
Annexure.
B, my lord. The other extreme which I'm going to tell you about. Lordship will have a compass of what we are doing across 3 or 4 instances. Then if Lordship finds it appropriate, pass the order, general order, and then apply it to this case. It's our suggestion. Our suggestion.
Page 66. This is the notice.
This is the pre-show pass notice. This is the intimation. My lord, the cyclostate standard one where they fill the gaps and get it. Simply say there's a difference between the ST3 returns and the value in the income tax. As for income tax return filed by you, the party for the financial sources, observed you declared income towards sale of service. Whereas in ST3 return, financial gross value is declared and so on. Difference you explain and they set out this could be the difference. 47 Annex C.
This is the reply.
And what is important, my lord, 68. It's the petitioner, my lord, is the real estate construction. I told you last week that construction industry, they all service tax will be accounted as and when they receive the money, they start. Income tax, my lord, we may follow percentage of completion method of recognition or completed method. The year I complete the project and account for the entire profits, or I may do it in stages. So I had told them that specifically page 68.
Yes.
This might not come to just above my signature. Based on the above requirement, discharge the service tax liability based on receipt by making sure that the cumulative receipt is always higher than the cumulative revenue amount as indicated in the idea for each project. We are hereby submitting the reconciliation for the kind of. It is clearly evident in the reconciliation the amount considered for arranging a testing liability cumulatively is much higher than the income declared for each product cumulative. Therefore, we have attached copy of reconciliation statement of income between income tax return and service tax Annex 1 for your time reference.
So you had furnished a reconciliation statement.
Annex D. I get one more notice from another free. What we see pattern. Last 3 lines. However, no registration statement has been furnished in the letter. The service tax has already been paid on differential time. Standard letters going on. I didn't leave it at that. Next year, E may not say reflect that also. Actually, read page 17. See, para 6. Again, I find includes another reconciliation. Please find and includes reconciliation statement of the revenue declared in P&L account, the value declared in STP returns for 2015. I said the same thing. As for the reconciliation, it's clearly evident that the revenue sale of land is not disclosed with STP return. As for the service tax, government tax is not applicable on the sale. But the real estate construction land value is deducted in only the works contract value is subject to tax is a settled law. So I give them that explanation. And I've given them copies of the agreement, sample copies of the agreement. But in spite of this letters which I have filed, see, because notice having been issued, page 14.
Yes.
What they say, para 5. The reconciliation statement submitted. The assessor have not explained the reasons for adjustment. The reasons not reflected. Methodology for calculating payment is only illustrated. The reasons are not included. Turnover and exempted was not back to detailed. This is what it is. So I'm giving them the reconciliation statement. They say your reconciliation statement is not sufficient. You know, I've given them reasons. This show cause notice. This notice may not be naturally you have to come here because they have decided they don't want to follow provisions of law. They simply want to confirm the demand. So we come here and we have shown that this decision right on this point because I put to seize with this very issue. And I say you can't issue a show cause notices based on ST3 IT returns because the basis of income is completely different. IT and ST. One foundation, as part of my compilation, it's a common compilation set 5.
Yes.
There my lord will find 140. It's very same issue.
The compilation. So let us, I made some markings. Page 40.
140.
Firm foundations.
Firm foundations.
Yes.
Not 60. What day? Okay, para 11, page 140. The question is. Before we do legal issues arrangement.
Paragraph.
Para 11.
Yes.
before making legal issues arise from the terms of the P&L account of the petitioner is determination of point of rendition of service, the method of quantification of receipts in respect thereof, and the application of Rule 3 itself in the admitted facts and circumstances. Rule 3 specifically provides clarity in the determination of point of tax. And the respondents merely applied the said rule to determine taxation services related to petition. The basis of assessment would have been perfectly in order. The flaw as I see arises from reliance of the respondent upon the entries in the P&L account to determine point of taxation service rendered and quantification thereof. Before going to the basis of the SC and the input order, I extract the basis of finalization of P&L account itself. Admittedly, financials including P&L account have been prepared on the basis of accounting standard issued by the ICAI. In the present case, the petitioner states unambiguously with respect to the SC that the basis of preparation of financials as far as the income from the bidding project is concerned is the project completion. Now, they set out the then my lords will see para 18 that they say the foundation of this is our big 140. The foundation of the assessment is that in making plot. They still call upon the assessment produce material in support of the stands and paragraph 11 states that the audited balance sheets financial year so statement recorded worksheet and written submissions are the basis of issue dates. By way of replace the petitioners on so days explains yet again that the P&L account cannot be the basis of the assessment. The impute order is passed, notwithstanding objection raised and negating the same. Then my lord, they set out from paragraph 21 onward. What is the rule 3 of taxation? The document will come especially to 25. Instead of such determination by application provisions of Rule 3.
Yes.
Instead of such determination by application of provisions of Rule 3, the respondent relies upon the P&L accounts to conclude the amounts reflected therein have not been offered to substance. The reporting of income to P&L being irrelevant for the purpose of determination of service tax payment. The basis of the income assessment is not. It is well set in position that the statutory provision of rule addresses a specific scenario. Such rule provision is liable to be interpreted on its own strength and context, and one needs more further to alternate sources to seek clarity in regard to the fact that has been addressed with the aforesaid rule provision. I am conscious of the fact that indeed Mr. Sudhir has repeatedly emphasized that there is an alternate statutory remedy available in respect of the impute order, and as such, there is no warrant for the interference of the court in extraordinary jurisdiction. However, all relevant facts are both learned counsel concur on position agreement that provides the landmarks and stages of completion of work petition, consequential payments of petitions available to the party. The petition is also made an annexure tabulating the consideration actually received from the customers with lump sum as against the amount that would be paid in accordance with the landmarks of the contract. To illustrate that almost all cases, the advance received is in excess of what would have been received. If the consideration has been received stage-wise, it is for the assessing officer to evaluate, examine the same, and sought further information to satisfaction completion. Yes. The facts and circumstances are focused upon the basis of the assessment is the contrary to provisions of Finance Act 1994. I inclined to it. The interpreter strike down this order. And what happens if the Lord does that? This is what we are saying. If you wanted based your assessment, if you based it on the SP3 returns that I have filed in this case, when I put the other extent. I filed the SP3 returns, I am an assessor. Like firm foundation. If you wanted to proceed, you should have taken the SP3 returns, questioned it, and then proceeded. You have not done that. You have not doubted the SP3 returns at all. You have not proceeded on Rule 3, point of taxation. You have rather taken the income tax data and said, even if you give me reconciliation, I will issue for customers. If I give, I am not satisfied with whatever explanation you give. I give free explanation. I am not satisfied. I will issue. My lords are not restricted only to the geographical location of that. Having that is why my lord the board has issued the circular. Don't issue indiscriminate notices. I am saying this service tax authorities will conduct an assessment in terms of the service tax rules. They are not permitted to conduct an assessment beyond the rules. This is what I am saying. So that is why the jurisdiction. So this, my lord, is the worst case scenario for assessing status. Best case is what I have already told. Exempted those cases. This is the worst case where I am registered and paying service tax. Even for these services, this is the kind of notices that are breaking my lord.
What is objections filed?
My lord, set out the focus. Have paragraph my lord. Ready? Well and ready. Fine. And 11 number. Let us see how they issue this because of the para 5. There are 5 things.
Para?
Para 5 of their counter.
A page?
Paging it. Please not page. Right. It's two.
Just one. Just one. $57.2. 57.2.
7.29.
By 9.9.
Before para 5 now. I told you lot of 3 or 4 letters which are submitted. What is? However, the petition reflects that neither explained the reason satisfactorily for the said declaration.
Paragraph?
There are 4 last 4 paragraphs. The last 4
Yes,
paragraphs.
yes.
However, the petition reflects that neither explained the reason satisfactorily for the said declaration. Are sufficient supporting documents submitted by the department. Verification of details submitted. Focus notice as to provisions of finance and 94 groups paid director issues valid as para 2.8 master also stated for regarding non-quantification of duty demanded with genuine grounds. The income tax return is only a basis to know the source of income declared in the petition. Source document. The source of such revenue from sales and shown in income tax returns will only indicate. And accordingly, petitioner was asked to clarify the discrepancy. And in the absence of sufficient clarification, explanation, sufficient documents, evidence, the STN was issued to the Department of Aforementioned. 6-7, they say what was the notice issued, whether extension of time, etc. And as he suggested, para 10, what they say. That's what the provisions.
Para 9, you just start from para 9.
Show cause notice offers the petitioner an opportunity to submit oral or written submission before the adjudicating authority charges under the case. As a circular so it states that even though it is desirable the demand is quantified in this case, however, due to some genuine grounds, it is not possible to quantify the short period in time of issuance. SCN would not be considered as invalid. The present case also the SCN was issued due to absence of sufficient clarification of the petitioner. And hence the SCN issue cannot be considered invalid without going into the circumstances of the same. As for the provisions of Finance Act 1994, it is the responsibility of the assessee to self-assess and discharge the tax liability.
Just one.
Yes.
Now, my point to all the council for the revenue. Now, we are at the, if we were to say that the show cause notice and interpret the circular and say that the show cause notice requires to quantify, at least in approximation, because show cause notice is the starting point of adjudication. Then everywhere notices will be set aside, inquiry liberty will be reserved to make your inquiry and come to a preliminary come to a basis, basic premise, which must be part of the show cause. Then we need not enter into the merits.
But accurate quantification, at least approximation is not there. That has been done in this. That is the law. I understand. Now, if I quantify without varying, and they say that as per understanding, man, limited in knowledge. I leave it to him. My limited knowledge would say is this. Because notice quantifies an amount. The order cannot quantify an amount different. It can't be more than that. Be less than that, probably. It can't be more than that. Setting law. Show cause notice is the basis of the entire proceeding. You should put me to a specific charge. If you can't even ascertain the amount before you issue show cause notice, you should not have even issued that notice. Because you are not making a charge here. You are not saying this is what is short paid. Lordship see section 73, it talks of what is short paid, not paid. It doesn't say any amount. What is the amount short paid, not paid? I should put notice. So it has to be a specific amount. You can't take a stance now saying in the order I will determine the amount. It's not the case. In fact, my lord, that has been made clear in the GST law. GST law says very clearly in section 75. You can't take a ground other than what is there in the show cause notice.
No, that is there.
It's there in the law. This was the law which was settled so that the show cause notice should put me to a definite charge. Should crystallize the amount and say this is what has been short paid. I answer that charge. I can't be left with the whims and fancies of the assessing officer who will say tomorrow the amount has changed. I am going to change the amount at my whims and fancies. That cannot be done. That is why my lords, the circular was issued saying you do this exercise before you issue show cause notice. Please come to that. That's paragraph 3 which I got to show you. This exercise, my lord, has to be done before issue show cause notice. It's 210, my lords, of my company. Once again reiterated that instructions of the board to issue show cause notices based on the difference in ITR, TDS data and service tax returns. Only after proper verification of facts may be followed diligently. What they say, my lord, is to take this before you issue focus notice. You are supposed to do this diligently. Can't say that after I give reconciliation statements, 3 or 4 which I give, you can't suddenly drop a focus notice on me and tell me, I'm not satisfied with whatever reply you have given. Focus notice for the entire amount. I'm not going to look into your reconciliation. Can't be done, my lord. Just write a board circular on it, saying, please exercise caution before you issue it. That stands, my lord, my humble submission can't be countenanced. And it's contrary to section 73 of the patent. Because there specifically say short paid, non-paid, so that has to be made known to you. I can't say approximately 34 lakhs is payable by you. That is not focus notice. That is just an estimate. This is an estimate. Therefore, even now, my lord, my humble submission would be this. In that, Lordships has seen the cases of exam, how focus notices have been issued. In a case where the assessing registered also, how notices are being issued without doing the basic homework, even if I give a reconciliation. These are the two ends, two extremes. In between, you will have various kinds of. Where my lord, they will take 2 years income, 3rd year income, they will estimate at 20% and add. This has happened in many cases. But the Lordships broadly laid out that these are the factors which can or cannot be done. Then my lord, the submission will be that if this submission is once the Lordship lays down the law, you apply it to this and if the focus notices do not meet the standards set out by your Lordship.
We can do one thing. What we can do is we can take those matters, the pleadings are complete. Now, I don't want to put pressure on the department. In those matters which pleadings are complete, we'll take it. We'll keep it aside. And we will hear those matters and we will dispose of those matters. The rest of it can be kept in abeyance till whatever. So wherever pleadings are complete, nothing further requires to be added. So those matters we'll make a category and we'll make that, we'll bunch those matters. Even if there's any change on Friday, those matters we'll keep it as a part one and dispose of only those matters where pleadings are complete.
But since all these matters fall under one or the other head, because they are not controversial, the fact that they don't fall under those overheads which was suggested by me, they fall under one or the 4 heads. So, what applies to what a Lordship take the 4 or 5? So automatically applies the other batch also.
No doubt, but in case they have some instructions which they want to place on record, since there are some matters, so what we could do is for the time being, cull out all those matters where pleadings are complete. And the argument that have been advanced is common to all and dispose of those matters where pleadings are complete.
Last time, case where, one case where there is an exemption under reverse charge. Today I have shown your Lordship where there is an exemption, straight exemption in Chinmaya Hospital. And another case where there is service tax payable, levied, registered as where also the same. My understanding may not this covers the category already, and pleadings are complete in these categories. So if the Lordship speaks it, I leave it entirely to your Lordship. Feel free. They lay down the law after seeing these 5 cases. And let that law be applied to the other cases. Our humble.
No, so that's what we can do. These 5 or 6 in which pleadings are complete, we will decide those matters. I will lay down whatever it is. Rest of it, we'll take care of it in the basis of whatever direction general. If we were to give in these 5-6 matters, the pleading is complete, it would follow.
then we will order it. Before the order. They will be issue only that the order should not survey in the disposal of.
No. What I'm saying, so we'll take out from this bag all matters in which pleadings are complete, so that your stand on the facts, whether it requires further investigation, whatever it is, your stand is placed on record. In those matters, there will not be any further inputs except on the position of law. We'll make a list of all those matters the pleadings are complete, and that we will take and we will continue to dispose it of. The rest of the matters. And then the rest of it may take its course.
Can I suggest something?
Yes.
Take this matters. The sanitary banks remain. 5-6 cases we take, and then we go through the lordships standards. The general principle that we are saying would apply. And my lords, all of them would be disposed. Now this.
The only difficulty is, suppose in some matters they want to take some stand which is factual.
They will still have time for that. They still have time. Most of there are 40 matters. Many of them are 80, 90. They're not filed probably, or some of them they filed, some they are not filed. Even now, the lordship sees the spectrum of these cases. Pleadings can be only this sort.
So how many matters pleadings are complete? One by one we'll go. 5 things.
959.
Huh?
6 matters.
We'll do one thing. Now I will adjourn the matters to tomorrow. You can just sit with the court officer and see what matters clean, cull it out. Tomorrow we'll make that one. We'll see how much. Now suppose about 70% matters pleadings are complete, then we can retain. That we'll see. We'll take a call tomorrow. Just make a list of how many matters objections are filed. We'll relist it tomorrow and take it. Relist the matter tomorrow. Interim orders in operation will continue till tomorrow. Yes. Yes.
May I make one submission, Malon?
Yes.
Serial number 48 in B group.
Yes.
This is a matter under the service tax. The refund amount is paid. The writ petition is seeking interest, Malon. Under section 11BB of the Central Excise Act. Under law, the interest is mandatory. The refund is already paid, but the interest amount is not paid. May I request the matter to be taken up tomorrow, my lord, in the preliminary list? For a preliminary hearing, my lord. Objections haven't been filed till date, but it's only a question of law, my lord.
Submission being made in 48. That refund is paid. Refund is paid. What remains is they are seeking for interest for delayed payment. They're saying that the position of law. Let us see next week.
Day after tomorrow, my lord, if I can take a chance.
2 days, the last 2 days, I don't want to have many matters. We'll have it next week, let us see.
May I request for a date, my lord?
48, 48, isn't it?
Yes, madam. 48.
Is the matter week commencing from 7th.
Great, sir.
What name? Srihari?
So just make a list of the whatever we can. So what I propose to do tomorrow, after finding out in how many pleadings are complete, we'll have that as part heard, and the understanding will be that the others, in order to avoid any conflict, the others may be deferred, where pleadings are not complete, awaiting the orders to be passed in these part heard matters. That's what I propose. No, but then we don't know that. No, but then you must complete your pleadings at least in 2-3 weeks. 3 weeks at least. Because if the pleadings are not complete, then perpetually it will remain.
There's another way I may suggest. It's a completed file. Put through those pleadings. We have gone through the 2 pleadings, they are general in nature. Specific comes out of these pleadings.
No, otherwise,
If we can find a common ground, and that is what it's going to be.
no, but they'll have some lingering doubt. Instructions are not complete. They have that. No, they have some compulsions from their side to at least place it on record. Then the decision may be different. So if we were to keep the whole batch as part heard, then those where pleadings are complete, we'll have to hear, or we'll have to wait till pleadings are complete in all matters. So we can fix a date for completion of pleadings, and then take up the arguments once and for all. If both sides agree.
We are perfectly agreed on that.
3 weeks, can you complete pleadings? 3 weeks. So then we will say, I'll just pass the brief order saying that common questions arise. In some of the matters, objections, pleadings are complete. However, to split both matters in which pleadings are not complete and other may not be practicable, as there may be there may be contradictory orders passed. Accordingly, matters adjourned for pleadings to be completed in such of the matters where statement of judge not filed. List after 3 weeks. In case of emergency, if you are not able to file, I will still accommodate. After hearing the common arguments have been advanced regards to the nature of show cause notice to be issued. 11th Senior Counsel Shri P. Raghuram appearing for the petitioner in some of the matters. That apart, The counsels for the respondents, however, have completed their pleading only in some of the matters, as there would be an overlap regarding the contentions to be dealt with in all of the matters. In light of the contention that show cause notice is required to be framed in a particular manner, as argued on behalf of the petitioners, all matters are required would be taken up after pleadings are complete. This would also ensure that the revenue places its stand apart from the legal questions on the factual aspects if required, so as to enable the court to dispose of the matters. In order to avoid piecemeal hearing of the matter, the revenue is directed to complete their pleadings in all matters where objections are not filed. Objections to be filed within a period of 3 weeks. These matters, the week commencing from 21st of August. The interim orders in operation would stand extended till the next date. Now, whatever matters are there will freeze this group. It will become unwieldy if suppose other matters, let other matters go before the roster. You can make a request that we leave it at that. Yes. Matters treated as heard in part. No, that's yes. Yes. And some motion for adjournment was made. Huh?
ಕಟ್ಬಿಟ್ಟು ನೀನು ಬಂದ್ಮೇಲೆ ಆರ್ಡರ್ ಶೀಟ್ ಬೇಕಾದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡುವುದು ಏನು ಬೇಡ ಬೇಡ ಅವರೇ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ತಾರೆ. ಯಾವ್ದು ಅದಾ? ಒಂದು ತಿಂಗಳು ನಮ್ಮೊಂದೇ